Shakespeare has Juliet ask, "What's in a name? That which we call a rose by any other name would smell as sweet." But with the Justice Legislation Amendment Miscellaneous Bill number 2, we have no issue with the name because the matters it covers are miscellaneous indeed, ranging from phone calls for young offenders to calling midnight on the sunset clause in section 93Z. But of course, miscellaneous has two meanings, both of which are still current. The original understanding of the word, as first used by Cato the Elder in relation to grapes from which wine was to be made, was not mixture, but very small or insignificant. For the wine of which he spoke was not to be a blend of mixed grapes, it was single origin, even though it appeared to be the type of cheap wine that is of minor quality, best enjoyed perhaps with a 3-day growth. This bill may call for a miscellany of changes, but while some of them are minor and belong appropriately in a miscellaneous bill of this nature, we have concerns about 4 significant changes to be introduced by this bill. Changes which are not minor and do not belong in the grab bag of mixed changes with which we are presented in this bill. Changes which, if they are to be supported, need substantiation and proper time for debate, and changes which cannot be supported in the absence of this time for adequate consideration. I will confine my remarks to these matters. Clause 4 of the bill repeals the Crimes Amendment Prosecution of Certain Offences Act of 2023, with the consequence that the sunset provision it introduced into section 93Z, subsection 4 of the Crimes Act will also be repealed. This sunset clause, due to commence on the 2nd of January 2026, was inserted at the same time as a requirement for a statutory review to enable this Parliament to consider the impact of the change to permit police officers, as well as the DPP, to bring prosecutions under section 93Z. Unfortunately, this statutory review was provided long after the statutory deadline, demonstrating a lack of respect for this Parliament and a disdain for the legal requirements imposed by legislation. This has made the work of reviewing the operation of these changes very difficult and impacts on decision-making about the sunset clause. The statutory review, when finally provided, indicated that only 2 prosecutions had been brought by the police, and at the time of the review, neither of these prosecutions had been concluded. Scant evidence indeed to assess the impact of important policy changes. There is also a question of the impact of the repeal of the Crimes Amendment Prosecution of Certain Offences Act on the changes made to section 93Z, subsection 4, to extend the ability to prosecute under this provision to police. We are comfortable that both police and the DPP can bring prosecutions. We have a strong interest in this provision being enforced. However, we are concerned to ensure that private prosecutions cannot be brought under section 93Z, which would have been the effect of the government's original amendments. We understand the government's argument that section 30, subsection 2 of the Interpretation Act will ensure that, despite the repeal, section 93Z, subsection 4 will remain in its current form. We accept this argument, but believe that this issue is so important and that there is such strong public interest in section 93Z and its operation that we will be moving an amendment to add a note for clarification. I now turn to Schedule 7, Item 2 to the bill, which seeks to repeal Section 258 of the Crimes Administration of Sentences Act of 1999. This section requires the Supreme Court to periodically review in open court information about persons on remand who have been in custody for more than 3 months. The government tells us that these reviews no longer serve a useful purpose. They tell us that there are now robust case management procedures in place, and so Section 258 is no longer necessary. However, the government does not substantiate these assertions. This change appears to be supported by no cited research, no discussion paper, or any apparent consultation with the sector. All we have to support this significant change is the opinion of the government. And this at a time when we have witnessed a significant growth in the remand population under this government. There has been a 20% rise in remand numbers of adults over the last 2 years. and remandees now make up 44% of all inmates, according to Boxar. This explosion in the numbers on remand is why this government had to find over $100 million extra in the last budget, or 14 times the cancelled investment in Business Connect, with enough left over to fund the ACT's community justice centres as well. We now have more prisoners on remand than we had in 1788. We have never had so many prisoners on remand, yet we are asked to wind back oversight mechanisms because the government tells us we don't need these measures anymore. And this from a government who said that electronic monitoring of those on remand for all but certain domestic violence offences would simply be too hard and beyond their capacity. So we will be holding even more prisoners on remand, even though electronic monitoring is a cost-effective way of keeping the community safe. We have seen no argument to support these changes, and so we will be opposing them and moving an amendment for all lines in Schedule 7, Item 2 to be deleted. Schedule 9 to the bill seeks to amend the Firearms Act of 1996 to facilitate appeals by minors with respect to a firearms prohibition order made under that Act by the Commissioner of Police. The Commissioner is empowered to make such an order if any person is not fit in the public interest to have possession of a firearm. And Section 73, subsection 3, provides that the Commissioner may revoke a firearms prohibition order at any time. Adults currently have a right of appeal to NCAT, but minors do not. This bill would confer these appeal rights on minors. The government argues that this will address an anomaly which has existed since 2013. But yet again, they have provided no details of the need for this amendment other than, trust us, we're the government. We ask for details of how many children are the subject of a firearms prohibition order. How many have been impacted since 2013? What have these children done to warrant a firearms prohibition order being made? The only answer we got is that there are apparently fewer than 20 minors who are subject to a firearm prohibition order, but we do not know why or the circumstances in which these orders were made. Minors are unable to obtain a firearm licence under Section 11 and are unable to obtain a permit under Section 29 other than a minor's permit under Section 32, which requires the minor to be under supervision and for firearms training or a target pistol permit. Their access to guns is already heavily controlled, as it should be. This amendment would require police to either brief others or attend NCAT hearings every time a firearms prohibition order was contested by a minor. Given that we are short over 3,500 active police in New South Wales, and we have a crime crisis where our citizens feel unsafe, why should we be asking police to spend their valuable time attending NCAT hearings rather than policing the community? A case for this change has simply not been made out. It is not often that I agree with the Premier, but in this instance I do. He has recently said, quote, "We won't be supporting any provision in the bill that will water down gun laws in New South Wales. They've been important pieces of law keeping the community safe for a long period of time," end quote. And this government has simply not explained why these changes to the Firearms Act are appropriate for community safety at this time. I indicate that we will be moving an amendment to delete Schedule 9 in its entirety. Schedule 3 addresses some of the concerns raised in the context of the equality legislation debate about changes to birth certificates. As Shadow Attorney-General Alistair Henskins said in that debate in the other place on the 16th of October 2024, quote, "As a birth certificate is a person's primary identity document, there are also concerns about the manner in which the bill specifies that any changes must not indicate on a person's record any alteration to a person's sex, sex descriptor or person's name under sections 32 capital F subsection 5 and 32 capital G subsection 5. That effectively means that a new identity is created. The possible implications for law enforcement and fraud require consideration and investigation. It is pleasing to see that the government has finally responded to these concerns and that these amendments address those issues. The bill will allow law enforcement, among others, to access original birth records to establish identity. However, I note this is hardly a minor matter and a surprising matter to find tucked into the schedules of a miscellaneous bill. While this change is welcome, it does not address all of the issues raised at the time about issuing new birth certificates. The bill still does not provide for any indicator of change of sex on birth certificates. This is consistent with the purpose of the legislation, but may create problems with the validity of certain marriages. The Commonwealth Marriage Act requires that if a marriage is celebrated by a minister of religion who is also an authorised marriage celebrant, it will only be legally valid if celebrated in accordance with the authorised rites of that religion. A number of religions require marriage partners to be of different biological sex, and a marriage between two persons, regardless of what their birth certificates may indicate, will be invalid if this requirement is not fulfilled. So we are seeking to amend the legislation to extend the category of persons with adequate reason to access original birth records to include a religious marriage celebrant only for the purposes of ascertaining the validity of a proposed marriage and with the requirement to maintain confidentiality about the information which has been accessed. This will prevent any possibility of persons believing that they are married who later discover that their marriage is in fact invalid. We are satisfied that the other matters contained in this bill are truly miscellaneous in both senses of that word, and we are happy to support those changes.